Good morning, ladies and gentlemen, and welcome to our final IR Chamber session of the year. I'm Vaughan Buerta, and with me I have Jacqueline Azel, and together we will be uncovering the hidden pitfalls of fixed-term contracting in today's session. So if I were to tell you that Section 186 of the Labour Relations Act defines dismissal as an employer that has terminated employment with or without notice, that would be not strange to you, because we already know that to be able to terminate an employment contract within the South African legal framework, it has to be with due process and for a proper reason. But what if I were to tell you that dismissal also means it's when an employee is employed on a fixed-term contract of employment and reasonably expected the employer to either renew the contract and the employer didn't, or to retain them permanently and the employer failed to do that. Well, we already know that the risk for unfair dismissal is up to 12 months compensation or re-employment or reinstatement. So I hope we have your attention, and please take note that the tips that we are about to share with you today are undoubtedly going to save you a lot of time and a lot of money. So Jacqueline, fixed-term contracts have and probably will always be a contentious labor law matter, especially after COVID. Companies have had to have a look at alternative contracting models. And once again, we're seeing the reappearance of the problematic fixed-term contracting model. Weirdly enough, there's a place in our labor law market for it. And if used properly, it is highly effective. But if you do not know how to use it and when to use it, it's undoubtedly a little bit of an obstacle for employers. Once again, thank you for your preparations and your insights today. We look forward to hearing what you have to tell us.
Thank you very much. And good morning, ladies and gentlemen. Yes, I look forward to sharing on this particular topic with you. And I would like to start off with a little bit of context as to where the law of contract for South Africa originated from. We are used to talking about this act number so-and-so from this and this year, but we don't have an act, the Contract Act so-and-so from year 1993 or 1932. Our law of contract actually originates from very ancient and different sources. The Roman law, dating back before the year naught or before Christ, the 17th century Dutch law, as well as English and American jurisprudence. And from all of that, what is left for us is the Roman Dutch law and the English common law as the big basis of our law of contract in South Africa. So where do we find this if we don't find it in an act? We find it in case law. So over the years, different scenarios played itself out. It went to a court from ancient times to more recent times, and we find the law of contract based on these principles in court cases. So it's actually not so easy to find the answers. And what had to happen, like Vaughan said, specifically after COVID, but also in more recent times, we had to find a way to integrate very ancient principles into a modern society. And why did we want to do that? We want to mitigate risk in our businesses, and we also want to be able to prove what we agree. So, contra preferentum. I'm not going to use a lot of legal jargon today, but this is the one term that I do want to highlight to you, because if you see in the little green block at the bottom, I want to say we can agree whatever we want as long as it is lawful. All right. So the contra preferentum term means the person that drafted the contract will be interpreted against the drafter if there's ever ambiguity. All right. So remember, you can draft whatever you want as long as it's lawful. And also remember that you can protect yourself against this principle. If your contract is silent on contra preferentum and there's a dispute, the contract will be interpreted against the drafter, which in our context is usually the employer. So you can contract out of that as well. So it's really, really important to ensure that when you engage in contracts, that you engage with a service provider that can help you put something solid on the table. All right. If we look at current legislation, I'm going to point out the most important pieces of legislation that we try and marry with these ancient principles. We are in a society that has developed over the years. To use an example, Vaughan mentioned post-COVID. Previously, we would contract, you work Monday to Friday from 8 o'clock to 5 o'clock. Lunch is between 1 o'clock and 2 o'clock, tea, 10 o'clock and 3 o'clock. But now societies have changed. People value family time more. They value a balance between their work and their home life more. And now we see more and more hybrid models or remote working models. So our law of contract needs to keep up with that, and we want to draft so that we can retain people, but give them the opportunity to incorporate what they value more also into their work lives. So we also need flexibility in that in order for a business to respond to economic challenges and maybe to things like load shedding and increase in production and shortages of materials. When we also came out of COVID, a lot of manufacturing businesses could not produce at the same tempo because they struggled to get raw materials into the country. And all of these factors you will see will show how useful a fixed term contract can be, because we can make specific arrangements for specific scenarios. All right. So I said I will point out the pieces of legislation that is important. For us, the Constitution is always most important. Section 13 tells us that slavery is prohibited. So you cannot force someone to work for you. That is not an employment contract. And Section 23. And I specifically like Section 23 because Section 23 is one of the very few places that affords protection for the employer, because Section 23 says fair labor practices for everyone. The Labor Relations Act focuses on the employee. Basic conditions focuses on the employee. The Code of Good Practices that we see focus on the employee, but the Constitution says fair labor practices for all. The basic conditions of employment will also tell us what working hours we're allowed to agree on, what we're supposed to remunerate people, and if we make changes, to what extent we can change. To use an example, you may reduce somebody's lunch hour by agreement, but not less than half an hour. So the basic conditions of employment will give us a lot of the parameters of what is legal. So we can design what we want in the context of, for example, basic conditions of employment. Then we also have a code that specifically helps us to distinguish when do we have an employee and when do we not have an employee. This becomes relevant if you work with a independent contractor, for example, and you want to determine if somebody is an independent contractor or whether they are really your employee. But that is not the focus of our discussion this morning, but it's something that you can just keep in the back of your mind. If we then look at this specific code, like I said, I'm not going to elaborate on it, but the importance of the code when it comes to fixed term contracts is this particular code focuses on the protection of vulnerable employees. And I'm going to elaborate on what you see there, TES, temporary employment services. In the temporary employment services environment, we work a lot with fixed term contracts. And those are usually people that are remunerated under the threshold of the odd 18,000 Rand a month, and they get special protection in terms of the law. If we then look at the difference between, or the requirement of contracts, a lot of people may or may not know that it's not required to have a written employment contract. You don't have to have a written employment contract. You can have a verbal employment contract. But you will remember, I flagged at the beginning, reducing risk and probative value. It's much easier to prove what you've agreed if it is in writing. Now I'm going to use an example. Luckily not often, but sometimes I get a call and the employee would be employer would be very worked up and say, I have this person in my business and I don't want them here anymore, and they're irritating me and they're doing this and they're doing that. But, you know, I actually just want to let them go. And luckily, we don't have a contract. We never signed anything. And then I'll say, all right, let's slow down. Let me ask you a couple of questions. How long has this person been with you? No, for 3 months. Do they come to work every day? Yes, 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 yes. Sometimes they're a bit late, but they've been here every day. And have they been doing the work that you've agreed upon? Yes. Do you pay them? Yes. Do they take the money? Yes. There's your contract. You do have a contract. But basic conditions of employment in Section 29, there's a requirement for you to reduce the particulars of employment in writing. So, although it may not be an agreement where both parties signed, you have to give a document to the employee stipulating from point A to P. What are you going to do? What are your hours? Where's the place of work? The duties, the remuneration. There's a whole long list. But if you have a contract of employment, 99% of the time you'll also be compliant. So what is the slight difference here? You have maybe a verbal agreement with your employee. That is an employment contract. It exists. The only problem is you're not compliant. So if a labor inspector were to come and say, show me your employment contracts, you're not compliant, but it doesn't render your agreement with your employee null and void because it's not in writing. That's just a slight technical difference, but it's important to make sure that you have an employment contract, because that will then usually also make you compliant in terms of the basic conditions. If you employ an employee who earns below the threshold on a fixed term contract, the renewal of that contract has to be in writing. Just remember that. All right. Then I just want to share a little bit of interesting history again with you. You might have a contract lawyer or a law firm that drafts your contract, or maybe you read an article and you come across these terms: essentialia, naturalia, incidentalia, very ancient words, and I'm going to explain it in very simple terms to you. The essentialia of a contract is the things that will tell you what type of contract it is. So in other words, if you have an employment contract, there will be talk of services or your intellectual capacity that you're going to make available to me for us to develop something. And there will be talk of an employer and an employee and remuneration, right? If we talk about a contract of sale, there'll be a price and there will be a seller and a buyer and an item, all right? So that is the essentialia. Now, for the rest of my explanation, I now want to explain this by means of a pizza example. So in order for a pizza to be a pizza, you need something flat and doughy, and then some cheese and maybe a couple of toppings, even if it's just once or twice. Then you know you've got a pizza, all right? So what is the naturalia then? The naturalia would be the nitty-gritty, the add-ons, all right? So if we said essentialia is the pizza, the cheese, and the toppings, your naturalia would then be the nitty-gritty. What type of toppings? How much of the toppings, all right? So then it becomes more specific to your industry. All employment contracts should have an employee, an employer, a salary, and a task. But you understand now that the naturalia would be different if I employ an engineer. The duties will look different. The toppings will look different. If I employ a receptionist, the toppings will look different, because that is specific. It's a bit more detailed than to just be a pizza. It's what kind of pizza are we talking about? Then if we talk about incidentalia, that's actually an easy one to remember. Just think of incidents. Those are very specific things that you want to provide for in your contract. You don't have to, but what if you burn my pizza? Then I'm going to deduct the money from your salary. According to the BCA, this needs to be stipulated in your contract. Otherwise, later on, I'll have to get you to agree to that, which is a bit difficult. So make sure if there's very specific incidents that you foresee between yourself and this employee, stipulate it in your contract, right? So there's your pizza example. I don't think you'll forget naturalia and essentialia and incidentalia. But that is what puts your contract together. All right. So a couple of things to remember. Like I said, you don't have to reduce your contract to writing, but the onus of proof is much harder for the employer if you do not have the paperwork. So let's use an example. You employ a factory worker and you say to him, it's verbal, I need a machine operator and you're going to work Monday to Friday, 8 to 5, and the last Saturday of the month, 7 to 12. Great. The employee reports for duty. First week, Monday to Friday, great. Second week, same thing, on the money. Third week, punctual. Fourth week, Monday to Friday, 8 to 5, he's there. Come the last Saturday of the month, he's nowhere. And he says when you confront him, but I didn't agree to working Saturdays. So it might seem simple now, but if you can have a document where you can stipulate, why would you risk having to struggle to prove what you agreed? So start off with a solid contract, and from there you will be compliant because you've reduced the particulars of employment to writing, and there's a meeting of the minds. And what did we agree? And how are we going to cater for special incidents? It's all in our contract. All right. Now we're moving closer to the fixed term contract itself. And I first want to stand still a little bit, like I said, on the temporary employment services side of things. In 2015, quite a couple of changes came about for the temporary employment services industry. And we talk about the deeming provision. What happened is the unions felt that where we have this triangular relationship, we have the labor broker, we have the client, and we have the employee. The labor broker sends the employee to the client, and the employee works on the client's premises. What happened in the past is the client would, for some or other reason, not be happy and chase the employee away and just tell the labor broker, don't send this person back to me, I don't want them. Then it was the labor broker's problem to either place them somewhere or not have a job for them. These employees were very, very seldom protected and they did not have job security. The deeming provision went through all the different courts, from the labor court all the way to the constitutional court. It took about 3 years, from 2015, like you'll see there, until 2018, when the constitutional court gave us clarity. What the deeming provision says is, if the employee has been on the client's site for longer than 3 months, the employee will be deemed the permanent employee of the client. What does that mean? It does not mean that the employee can demand a permanent contract and now jump from the broker's payroll onto the client's payroll. No. The deeming provision says for the purposes of collective bargaining and fair labor practices, you will be regarded as if you are a permanent employee. So if the union on site starts to count heads for representation, they can count the labor broker's staff in. If there's discipline, the labor broker's staff needs to be disciplined in the same fair manner as the permanent employees. When it comes to remuneration, the labor broker staff cannot be paid less. Their cost to company must be the same. So again, an example, if the permanent employee of the client, the cost to company is 5,000 Rand, but 500 Rand goes for medical and 500 goes for housing. The labor broker employee doesn't have to get a housing allowance and a medical aid, as long as his cost to company is also 5,000 Rand. But there's no such thing as now, after 3 months, the employee can demand to be a permanent employee of the client. This is not what it means. The implications for an employer is, if your labor broker is unethical, or if you are the labor broker and the client does not abide by the law, and there's a dispute and it gets referred to a bargaining council, the employee can cite 2 respondents, the broker as well as the client. the employee can choose whether he takes both parties as a respondent or only one. And the commissioner can decide whether he awards compensation against either the broker or the client or both. So all I can advise in this situation is make sure that you do business with ethical people, whether you're the client, whether you are the broker. Make sure that your fixed term contracts are sound and properly drafted. And I will elaborate a little bit more on that as we move along. So the deeming provision, just to wrap up, there to protect vulnerable staff. And it doesn't mean you can demand permanency, but you can demand the same fair treatment as that particular vulnerable employee. So everyday use of fixed term contracts, there's a couple. The first example is for a specific event. So poor Justin Bieber didn't come to Cape Town, but let's say Greenpoint Stadium usually has 1,000 security guards. Then for the concert, they're going to need another 1,000. Then they recruit 1,000 security guards and they say to them, for the 1st of September until the 7th of September for concert week, this is what we employ you for. And I'm going to say it a couple of times. The contract must specify the event or the reason for the fixed term. It's very important. All right. So start date 1st September for the concert week, end date 7th September. That's it. All right. Then if there's a specific task or a project, the wine industry is a nice example for me because you have harvest season in the wine industry. It sort of starts towards the end of December, moves towards March, end of March, early April, but we can't say specifically. So you will employ additional staff to help you harvest all the grapes on this wine farm, but you don't know beforehand exactly how many grapes there are and exactly how long it's going to take. The weather can have an influence, for example. So you will then contract with the staff to say, I employ you for harvest season. It usually spans towards the end of March, maybe mid-April. And when we're moving to the last hectare of the farm, I will then tell you exactly when we will end this contract, because then we know the last hectare is going to take us a week, and we will give you a week notice as to when this project will end. Right. Then there's a whole long list. I'm not going to go through each one of them. I just want to highlight a few of the important ones. You can possibly replace an employee for a specific period of time where maybe somebody's going on maternity leave. You know exactly when she's going to leave, and if all goes well, you know exactly when she's going to come back. Then again, you'll stipulate in the contract, I appoint you to replace my receptionist who will be on maternity leave from this date, returning this date. This is when your contract will end. All right. If, for example, you are in a production environment and you blow mold or injection mold, the engineers always correct me, you injection mold the wheelie bins for a specific municipality, and there's a new proclamated housing area, and the municipality says we need 5,000 bins in the next 2 months. Your normal production and your normal staff cannot handle the increase in production. So then you call your labor broker and you say, I need blow molding operators. I need 10 of them for the next 3 months, because this is how many bins we're going to do. So there's an increase in production. Again, you will specify it's for the municipality ABC wheelie bins, all right? Because you don't necessarily want to keep these employees when you get another project. Maybe there's a different skill that you require, or so you want to specify, you 10 guys will work on this project. When we've done these bins, that's the end, and we foresee it's after 3 months. All right. Seasonal work, we spoke about that. A very important one is the last one. You will not believe me, but some employers' permanent contracts are silent on retirement age. Then they phone us and they say, but this person is now 67 and we want them to go. Can we tell them to go? No, because you don't have a retirement age specified in your contract. And that leaves you in a very undesirable position. But let's focus on our topic for today. We will say all of you have got perfect permanent contracts and there's a retirement age, and this is a fabulous employee, vibrant at 65, a lot of knowledge, a lot of experience. You want to retain them, but you don't know how they're going to feel. Maybe they want to get into the grandchildren a bit more, but you're going to try and say, all right, let's see, can we agree for one more year? We conclude a fixed term contract, you will work for us for another year. You're going to do exactly the same remuneration. And at the end of the year, we'll see whether you're still in good health, and you'll see if you are still interested. And then we can take it from there. So that's a nice example of where you would use a fixed term post the retirement age. Okay. It's very important to make sure that your notice clauses in your fixed term contracts are unambiguous. All right. Remember that we will always be guided by the basic conditions of employment. So if your fixed term contract is for 2 years and you want to give notice and the person has worked beyond 6 months, you will give 4 months notice. If your fixed term contract is for 3 months and for some other reason you need to give notice, it will be less than 3 months. I think possibly it will fall on the 2-week notice period. All right. The green block, I just want to flag that in some of your fixed term contracts where, for example, you know the exact period, the date is in there, start 1st of January, finish 30 April. We all know this relationship comes to an end on the 30th of April. We do pick up from the courts that they actually still expect us just to flag that termination date with the employee, even though there's a start and an end date. So safeguard yourself to say in your fixed term contract, we all know when the expiry date is, and should we remind you a couple of weeks in advance, it's a courtesy. Don't expect me to remind you. If I do remember to remind you, it's merely a courtesy. All right. So that's a little bit of an area where it's better to rather flag with the employee, and that's something that you're going to have to diarize.
Jacqueline, tell us about this probation clause. Can we use the fixed term contract for probation purposes? And I'm asking that for a very specific reason, because it's one of the questions we launched in our poll. And I regret to say that 35, well, even more, 59% of our attendees answered incorrectly. So please, can you elaborate on that for us?
Yes, with pleasure. I'd like to take us back to the Constitution, fair labor practices for all. What is the LRA's focus? The LRA's focus is on job security. And if there isn't a justifiable reason for a fixed term, you cannot lawfully use it. You cannot use a fixed term contract to determine whether somebody is suitable for a job. The test will lie in the job itself. So if you want to ask yourself, can I use a fixed term? Ask yourself whether you're always going to need this position. That's the golden question. You always talk about the golden nugget, Vaughan. So here the golden question is, if you are always going to use a receptionist, you cannot give her a fixed term contract and first see whether you like how she drinks her tea and whether you like how she sits on the chair. No, you have to give her a permanent contract, but the confirmation will be dependent on the successful completion of the probation period. A lot of employers use the fixed term contract because it rids them of the obligations you have if you run a proper probation process. A proper probation process can be a bit taxing because you have to have check-in sessions with the employee and you have to give them feedback and guidance and support depending on the level of where they're appointed. So some employers feel, oh, it's easy. I put them on a 3-month contract. I see if they make the grade and if I like them, and if I don't, out the door. But if that employee were to challenge it and say, Commissioner, but now they appointed another reception. I was in this role. I did the job well. I never got any warnings. I was never late. They never complained. But now there's somebody else and I've been doing it for 3 months. Then you've got a big problem. So Vaughan, I don't know if you want to add on to this.
Absolutely. And just for full disclosure, I'm not sure whether my good mentor, Mr. Rick McKaiser, has trademarked that reference, but he always speaks about the golden nugget. And I think it's so catching because it really gives you a proper test as to whether you can use the fixed term contract or not. I always advise my clients to ask them, are you going to replace the employee? Have you already lined up your successor? If so, you're definitely on the wrong track. And remember, they merely have to prove a reasonable expectation of continuous employment. If that's the case, you are deemed to fail. And what was quite interesting, Jacqueline, your list of reasons for the fixed term contract. So for those that don't know, in 2018, we had overall of our Labour Relations Act, there was public comment, quite a lot of proposed amendments to it. And one of the proposed amendments was exactly that, for probation to be managed via fixed term contract. And our government excluded that, and they said it's not it's not in the best interest of our Labour Relations Act and unfair towards the employees. So that was excluded. And one of the other very big insertions was Section 198 of the Labour Relations Act, which now gives us a very detailed account of how to manage fixed term contracts, and also speaks to those temporary employment service engagements. And very importantly, in those amendments, they stated that the reason for the fixed term contract has to be declared in the contract itself. Previously, it wasn't, and previously our fixed term contracts were managed on a reasonable exploitation test, but they've gone that extra hurdle to manage it, and especially with regards to employees earning below the income threshold, where they now say that for that 3-month window period, anything afterwards creates this expectation, and at that point you would have to treat them no less than favorable to your other permanent staff. So you can see how the legislation was drafted, exactly what you're saying, Jacqueline, how they're protecting those lower income or more vulnerable employees, part of our workforce. But thank you, I just wanted to add that.
Yeah. And also, Vaughan, when we look at the probation scenario, it immediately speaks to the vulnerable employees, because typically if you are recruiting an engineer or a doctor or an architect, you won't expect them to leave a permanent job to sign a 3-month fixed term and risk maybe not getting appointed. So typically employers would use this fixed term probation scenario more applicable to the vulnerable employees. And it's exactly those employees that actually need more protection. So that is part of the reason, like you rightfully said, it was excluded from the justifiable list. So also another red flag, repeated renewals versus the reasonable expectation. I'm going to elaborate a bit more on the reasonable expectation because that's a big pitfall. But the commissioner will dive under the employer's bed, lift up the bedding and ask a couple of questions to say, but if this is a job that you're always going to need someone in this position, why are you not giving this person job security? Why do you keep renewing this fixed term? You always need an electrician or you always need a driver. You cannot keep renewing this contract. That is a big pitfall. All right. Then once again, we've touched on the temporary employment services quite a bit. You cannot contract outside what would be deemed as fair dismissal requirements. All right. So if we look at the test industry, if the employee misbehaves on the client's premises, the client will phone the labor broker and the parties will decide. Labor broker, will you send your in-house legal representative to come and conduct the hearing, or can we as the client conduct the hearing? But the same principles of fairness needs to apply on for these employees. Right. The reasonable expectation. As is with the law, there's a lot of protection for employees, much less protection for the employers. So the hurdle or the bar, the onus of proof on the employee is very low to show that they had an expectation of renewal. They must only show that subjectively they believed that this contract is going to be renewed. So not objective, the employee needs to just show, but this is because of these things, why I believe this contract is going to be renewed. So it's a very low threshold, right? So what Vaughan said in his introduction is exactly this point. If the employee can show that he or she really believed that this contract is going to be renewed and it was not, that constitutes a dismissal for purposes of the Labour Relations Act. It's as simple as that. So what are the things that employers should be on the lookout for not to create this expectation? Habitual renewal, you see, is at the top of my list. If you keep renewing this contract and you keep renewing it, and then one fine day you don't, and then you put somebody else in that position, I'm willing to risk saying I can promise you 99% sure the employee will be successful in proving that he or she had a reasonable expectation. And when these things sometimes transpire is, you've got this receptionist, she's great, you keep renewing the contract, she's very reliable, and then the boss's uncle's daughter needs a job, and then she gets this job. This is typically where the habitual renewal will be a big pitfall. The availability of the position. I've said this a couple of times. The golden question is, if I'm always going to have this job, if I'm always going to have the need for the driver, the machine operator, the receptionist, the architect, then you should make that person permanent and not keep renewing this contract. People talk a lot and people don't always realize what they're saying. So let's say on the third point, planning the employee's future working schedule. Let's say the contract is on paper. It's supposed to expire on the 31st of December. Now towards the end of the year, in the tea room, you start discussing with this employee, you know, what does your plans look like for next year? No, we've got an exciting year ahead. You know what? We are awaiting these new contracts. And, you know, when do you and your family again typically take vacation? Oh, okay, April, blah, blah, blah. And you start this conversation where the employee can say to a commissioner, my employer actually asked me what my leave planning is for next year and shared with me the new projects for the next year. That's why I thought they're going to renew it, and now they didn't. So that's a problem. Okay. So conduct inconsistent with the intention to terminate, whether that's future talk or the other big pitfall is if you allow the employee to work past the expiration date. And this happens very often and very easily. Vaughan, you can just let me know if you need to add in something. So let's say everybody's very busy, production is pumping, the contract is supposed to end 30 November, and before you rub your eyes, it's 15 December. Now you call the employee and you say, okay, oh, you know what? Your contract actually ended on the 30th of November, so it's Friday today, but you don't have to come in on Monday. Enjoy the 16th of December long weekend. Cheers. Great. It was fabulous having you here. Then that employee is going to say, listen, but you allowed me to work for 2 more weeks. Now all of a sudden you tell me you don't need me. So all of these things will potentially be a big risk for the employer if you don't renew. And remember, I want to go to the next slide.
Jacqueline, if I can just add something there before you go to the next slide. Just a tip that I want to give to the attendees on this call today. So as we know, for your lower income employees, they are deemed or they should be treated no less than favorable to permanent staff after the 3-month window period. So some advice that I just have to the attendees today is always to make use of fixed term contracting, cost to company, salary contracting. It just eliminates that risk that after the 3-month period you're left with with a differentiation between the salary scales. The cost to company is quite good. And I must say, I read an article this week published by Mr. Jonathan Goldberg. He spoke about retrenchments, and he gave some advice and great advice in terms of retrenchment processes. And something he said really stuck with me, where he spoke about, as employers, we often neglect to share information with employees. And Jacqueline, as you said, with your harvesting or manufacturing productions, very often employees on shop floor level aren't privy to what is going on in the business and wouldn't necessarily see those fluctuations in production throughout the year. So what very often happens is we've got this process, employees don't really know what's going on. They can see that there's still production. And by that, then make the assumption that something has been done wrong by the employer. And I think in the South African context, we've got a very volatile employer-employee relationship, also exacerbated probably by unions. You know, we've got a lot of union involvement and industrial action in our country. And what we're seeing from our desk is that there's this sentiment, there's default sentiment by employees that, man, the employer must be up to something here. And subsequently, when they see production still going or that the business is still operating and they don't understand the rationale behind that fixed term contract, very often they then make the assumption or the inference that, man, something is being done and I'm going to go to the CCMA. Whereas what I took from Jonathan Goldberg's article was take some time to share whatever is going on, try to educate the employee. And I do think that that's going to help you prevent quite a lot of risk. And then just lastly, Jacqueline, that notice period principle, you're 100% correct in saying that the contract comes to an expiration automatically. It doesn't have to be effected. But I must say that courtesy notice period eliminates a lot of risk, and it always just helps you catch issues before they transpire. Because as I said in my introduction process, fair dismissal requires fair procedure and fair substantive reasoning. Now, the problematic elements of fixed term contracting is if that contract is not for fair reason and you terminate it, you also terminate it without fair process. So you automatically exacerbate your financial risk by itself. So by providing the employee just with a courtesy notice, at that point in time already, you would know whether you have an issue. And it just gives you a little bit of control back into the process to say, do you need to negotiate? Do you need to consult? And what can you do to try to eliminate that risk? Remember, once you have to go to the CCMA, you've already got risk. You're already going to spend time there, and it's a case that has to be presided by a commissioner. So those are just a few tips that I just wanted to share with the attendees today.
Thank you very much, Vaughan. Yes. Also, do remember, depending on the level of where you contract, if you conclude a fixed term contract that is going to be in excess of 2 years, you need to provide in your financial planning for severance pay. So if we use an example, you're going to appoint 5 engineers for 5 years for the expansion of the Gautrain project, you need to provide for a week's salary for each completed year on that project if your fixed term extends beyond 2 years. So that's just something that will have to go into your financial planning. And usually when we talk about the longer fixed term contracts, it's usually also higher salaries. We don't really engage in fixed term contracts with our lower earning employees usually for these longer periods. So that's just something to keep in mind in terms of your financial planning. Then if we look at the last bullet, it's like a bullet and a but going on to our next slide. Again, how you contract and what is in your contract is so important to mitigate risk. If you conclude a fixed term contract with somebody and you then have to terminate it, you need to have, look at the third bullet, it says you need to specify termination for any reason recognized in law, because what sometimes happens is you engage in a fixed term contract for 2 years, everything looks fantastic. I mean, I can't think of a better, unfortunately bad example than COVID. Nobody expected COVID or the impact that COVID was going to have. So let's say your business was prosperous. You concluded a fixed term contract with a fairly high earning employee for 2 years. COVID comes, you can't operate. Now you have to retrench. So you need the clause that says, I can terminate this fixed term for any reason recognized in law. For example, your section 189, which is a lawful process when there's operational requirements. All right. So important clauses, your start and end date. Like Vaughan said, you need to specify the reason for the fixed term. Even if there is an automatic expiration and notice is technically not required, we see the courts appreciate it if we do the courtesy to remind. All right. I want to stand still. We're drawing to a close now, but again, the fourth bullet is very important for me. Yes, we can agree whatever we want as long as it's lawful. In Afrikaans, there's a saying, papier is geduldig. So if I translate that directly, it would say paper is very patient. You can put on a paper whatever you want. And sometimes people or employers are under the misconception that if I write in my contract that nothing that I do will create an expectation, it will not safeguard you if you exhibited some of those examples that we gave. Even if your contract says that you can't expect a renewal. If I talk to you about next year's planning, and if I allow you to work beyond the expiration date, then having this little sentence in your contract will not protect you. The commissioner will pull away all the linen. He will look, or she will look under your employment bed and say, but this and this and this and this is what you've done to create this expectation. So this little sentence in your contract will not protect you. All right. So do remember your notice clauses, your reasons for the contract, very important. And it's actually fairly simple. I want to start at the bottom of the slide. Diarize the dates of when your fixed term contracts will expire. If it's human resources job, if it's your job, whether you use an iPad, a laptop, a phone, an old-fashioned diary, diarize these things so that you can, like Vaughan said, in good time, take up the conversation, remind the employee, and if there's anything that you see is a bit disturbing, you can try and get ahead of it before you get to the expiration date. All right. First bullet point, even if this is the only thing that you take away from today, we do not draft for the good times. From time to time, people will phone and say, listen, I need a contract, but nothing complicated, just like a little one-pager. You know, it really, I don't want a long thing. We do not draft for the good times. We draft for the bad times. So that's when we go back to, yes, we all know we're going to do pizza. There's the base, there's the cheese, there's the toppings. Okay, we still also we have an understanding about the nitty-gritty, the naturalia, the more specific things we want on here, a bit of anchovy, a bit of shrimp. Don't forget that the devil is in the details, your incidentalia. That's where it becomes important. That's sometimes where your contract becomes an extra 2 pages because you provide for when the pizza gets burnt. Otherwise, second bullet, poorly drafted fixed term contracts. It reminds me of the ABBA song, money, money, money. And then it's not so funny. Like Vaughan said, the moment you get that dispute has been activated, your set down notice, already your time is money. Even if you go and sit and you settle, you spend time there. You don't want to go there. So remember, you minimize risk by putting your contract on paper because you can prove what you agreed, and at the same time, you satisfy the compliance that the basic conditions of employment requires of you, written particulars. The deeming provision, remember, for purposes of collective bargaining, for discipline and for remuneration, those employees need to be treated the same. We did speak a lot about the courtesy reminder of the expiration date. It's a nice way to just be courteous as well, especially if someone has given you good service. Maybe in future you want to again use them, or there's another project later. So the same principle applies for, I always say to employees, honor your notice period. Don't burn the bridge. The same for the employer. If you had a good relationship with a good employee, it's just the project has come to an end. Close it off nicely and with respect. And then maybe if you need their services next time, you know where to go, and they will be happy to again come and share their knowledge and skills with you. And there we just have a little slide of our sources. So Vaughan, that is my story for today when it comes to the fixed term contracts.
Jacqueline, thank you very much. We've had a few questions, and I just want to confirm for the attendees that our session of today will be recorded on or will be published on our YouTube channel. You can please provide for approximately 10 days whilst we just clean it up and then publish it. And you're welcome to like and subscribe on our YouTube channel. And you're also welcome to send us questions afterwards. If there are any items that we haven't addressed that you maybe need some clarity on, you're more than welcome just to send me an email and we'll get to those. But we've got one final question from Mimiki. Mimiki asks, what do you do when you have notified the fixed-term employee via courtesy notice, but the employee questions why you are not renewing the contract? I would like to provide some comments on that, and I just want to give you first an opportunity, Jacqueline, if you want to comment on that.
Yes, I'm quite keen to answer the question, because if we reflect on what we shared today, if your fixed term contract was drafted properly, the reason for the fixed term will be in the contract. And if you asked yourself the golden question as to, do I have a legal, justifiable reason to put this person on a fixed term, you will have no problem answering the question. So if we use an example of the maternity, then you can say, Madam, or maybe you had a male receptionist for a replacement. In your contract, we said it's for maternity relief. This employee will be returning from maternity leave. Or we said we're going to do the new municipalities bins. We finished with the new municipalities bins. That's why it's coming to an end. So if you abuse a fixed term, you're not going to be able to answer the question. If you use the fixed term for the right reason, you follow the law, you specify the reason, you will not have a difficulty answering that question. You will go right back to that written document that abides by the law.
Exactly. And Jacqueline, if I can add to what you're saying, is if the fixed term contract was used for a genuine purpose, that fixed term contract comes to an expiration automatically. You need not do anything as an employer or as an employee, although the courtesy email is proper. But I just want to go again to what Mr. Jonathan Goldberg said: educate the employee, talk to them, explain to them. But rightfully, as Jacqueline said, it's effected unilaterally and without anything that needs to happen by the employer. Mr. Rurik McKaiser is on the call. So Rurik, I've used your golden nugget reference here today, so I'm gonna owe you some royalties after this call today. But Mr. McKaiser asks, is there a difference between a fixed term contract and a temporary contract? That's a great question. I also hear the term used as limited duration contract, which is also something that they use. But Jacqueline, my interpretation is that it's the same thing. Our Labour Relations Act speaks, or our Basic Conditions of Employment Act speaks about two different contracts. So either a temporary contract or a fixed term contract, or that of a permanent contract of employment. So in my interpretation, they're the same. Just want to check whether you agree, Jacqueline.
Yeah, Vaughan, my only comment that I would like to make on that is, prior to the deeming provision, what we found a lot in the temporary employment services industry, they had these open-ended contracts. So it was relief work, but it was like ongoing and ongoing and ongoing. I dealt with clients where they would have sometimes temporary labor broker staff who's been there longer than some of the permanent staff. So the open-ended contract was something that, in my understanding, was exactly part of the reason why employees weren't protected, and why the law is now very specific as to when we use anything but, like you say, a permanent contract. There needs to be a reason. So let's say, for example, you don't even know how long it's going to take to build 3 more dams in South Africa. Still, you'll specify, I'm employing you to build 3 new dams in South Africa, and the contract will come to an end when we concluded the project. So if we follow the law now, there will be an end, either when the project ends or either when the timeline ends. So in my experience, where I found those very airy-fairy, poorly drafted, open-ended scenarios was more in the unregulated pre-2015 labor broking environments. And even if we were allowed to do that, I would steer clear, because it's so much harder to prove when you don't have hard and fast either a project or a timeline or a reason.
Absolutely. Then we've got another question from Lorraine. Thank you, Lorraine. Lorraine says, What if you do not have sufficient funds to match the rate of the fixed term contract with a permanent employee? Can I still negotiate with the employee on that matter? So, yeah, so Lorraine, Section 198 speaks about, again, your lower income employees earning approximately 18,500 Rand per month. And the Labour Relations Act, Section 198, is very clear on that. It says, after a 3-month period on the fixed term contract, the employees have to be treated no less than favorable to your permanent employees. Further to that, they should be able to apply for positions. Everything that you essentially do for your permanent staff should be done for your fixed term contract employees after that 3-month period. And remember, you cannot contract out of the law, and our law requires that they be treated equally. So, Jacqueline, my interpretation on that question is no, you can't. But I would love to get your input.
Yes, I fully agree, Vaughan. And although unions in South Africa are in some instances very obstructive, one area where I prefer to work with bargaining councils is where we see in the production environment where we have the client's own staff and then the broker's staff, where we have, for example, bargaining councils. The bargaining council will say a forklift driver earns X. You have to provide for Y and Z. So it creates already an equal platform for both these groups of employees. So no, you cannot contract to pay them less. That's a plain and simple answer. The law is very clear, not less favorable than the client's own staff. You cannot negotiate outside the parameters of minimum wages or bargaining council wages and benefits in the bargaining councils. For example, contributions to a provident fund or an annual bonus. Some of the bargaining councils provide for a bonus, provident fund, and those types of things. And you cannot negotiate for less, no.
And I think you always also have to interpret the Labour Relations Act within how it was drafted and the intentions. And you can see with the additions that were included in the year 2018, it showed additional protection to our vulnerable employees. And Jacqueline, I do believe that you would agree with me that I think fixed term contracts might have been exploited previously, and therefore what our laws are saying is that those people and people appointed on fixed term contracts have to be protected. And that's especially why the TES, the temporary employment services industry, was so problematic, because you can imagine how those employees were left between the client and the employer, and then nobody really knows whose employee this is. And they actually referenced that in that assigned services judgment, where the court also spoke about that employee needs to have protection. He can't fall by the wayside or in between these two parties. Somebody has to take responsibility for their employment. So unfortunately, if you look at how that was drafted, you're not allowed to contract out, and it almost wouldn't make sense to be treating them differently or to be contracting different salaries with them. Something from an HR perspective, though, your fixed term, say for instance, a 1-month or a 3-month fixed term contract, it's very problematic to put those employees on your medical aid funds or your provident funds just due to the administrative burden. But that's why my advice regarding the cost to company remuneration structure still serves as some guidance, because it at least enables you to treat them equally to your permanent staff without having to go through the administrative burden of registering and removing them from that fund every time that you contract with them on a fixed term basis. Jacqueline, I don't know if you have any final questions. It's been amazing just to have the audience engage with us with all these questions. Whilst we wait for the final questions just to come in, just want to check whether you have any closing or final comments on your side.
Yeah, Vaughan, I just think that if you try and circumvent the law and abuse the fixed term for the wrong reasons, you're going to fall in your own sword. So all I want to say is, don't try and take shortcuts. You might get away with it once or twice or for a couple of years, but that's not the ethical thing to do. If we look, like you said, Vaughan, at the Constitution, at the LRA, it needs to be fair for everybody. We want to protect the vulnerable employees. And again, for those who misbehave, follow the right steps. Don't use other tools in the law to try and get rid of people if they're not doing what they're supposed to do. Use the correct tools for the specific scenario. So if it's a probation situation, follow the proper probation process. If it's not really a need for a fixed term, don't go there.
Don't use it. Don't use it. And we've got one final question from Jean Stemmet. She asks, how is habitual renewal of fixed term contracts for an employee past the agreed retirement age currently interpreted by the court? So Section 198 fortunately gives us that mandate to be appointing people on fixed term contracts past their retirement age. And so, Jacqueline, my interpretation is very much still that as long as that is the reason for the fixed term contract, our courts permit that, seeing that it is past the retirement age. And remember, retirement ages are managed or have to be managed consistently in the company. One, everybody has to be subject to that same retirement age. The moment that you make an exception on that, it would be problematic. Therefore, the company really doesn't have any other option or choice than to be appointing employees on fixed term contracts if they've passed that retirement age. If doing so, you would severely compromise your retirement age policy.
No, I fully agree, Vaughan.
Excellent. Okay. Wow. I can't believe this year has come to an end. It's been an absolutely amazing opportunity for us to share some of our knowledge. I would absolutely welcome each and everyone on this call to be engaging with us on email as well. I know some of you have great insights and great ideas that you might want to share with us. And one of my colleagues, Esmeralda, always said, I think this is also something she learned from Mr. McKaiser, is that if two legal people agree, you should be worried because our law has to be interpreted and you always have to look at it from both sides. So we always welcome input and insights just to make sure that we keep ourselves sharp and that we anticipate risk guidelines. But for now, thank you very much. Have a blessed end of this year. Another 7 weeks left up until Christmas. And we hope that this year ends strongly for you and that our sessions have added and made an impactful impact on your business. So thank you very much. And Jacqueline, for you as well, for all your contributions. These webinars take quite a lot of time to prepare for. And I'm much thankful for that as always.
It's a pleasure as always, Vaughan. And thank you for everybody who took the time to join us this morning. Have a blessed festive season.
Thank you very much, everyone. Keep well. Bye.